Hi everyone, this is Molly. I'm the event manager at the FACC-Chicago. I know we're waiting for a couple more people to join in. And we'll get started in just a minute, just giving it one more minute. Please let me know in the chat box if you don't see the presentation. Does everyone see the presentation? Should be up on your screen.
Okay, thanks. Good.
Great. Okay, so I know we'll have a couple more people filing in the next few minutes. Go ahead and use a couple housekeeping things. Go ahead and use the chat box if you have questions during Michael's presentation. We have a pretty tight timeline today, so I'm going to go ahead and introduce Michael Turansick, who is our FACC-Chicago President and also happens to be an immigration attorney, thankfully for us. So I will let Michael get started.
Okay, thank you very much, Molly. I appreciate it. Good morning to everyone, and thanks for coming in on a Friday to talk about immigration. As Molly said, I'm president of the FACC-Chicago, and before I get started, I really would like for everyone just one reminder just for everyone. We are having La Nuit des Étoiles, our gala, on July 22nd, and we will be doing a virtual gala this year, like so many other organizations. And I encourage you, if you've been there before in person, or you haven't been there and you want to see what it looks like, it's free admission this year. It starts at 6:30, I believe, Molly. Correct me if I'm wrong later on, but it's 6:30, and we're really planning. Molly and Andrea have done a wonderful job so far planning what I think is going to be an interesting, informative, fun event. So please, please, please register. There's a lot of good work that the chamber does, and participation in the gala helps support that throughout the year. It also helps support our charitable foundation that provides scholarships, college scholarships to local high school students. So plug for the gala done. Let's talk immigration. Okay, so I think to put this week's proclamation in context, it's really necessary to begin with the April 22nd proclamation of the president that banned the entry of new immigrants to the United States. While that proclamation had relatively low impact because it only applied to individuals seeking immigrant visas from abroad, and because all the consulates and embassies had been closed for a while by then, it really didn't have much of an impact. So, but it did contain one ominous warning of additional measures at Section 6 of that proclamation. At Section 6, it required the Department of Homeland Security, Department of Labor, and Department of State to review non-immigrant visa categories and recommend measures to stimulate the economy and prioritize the hiring of U.S. workers. So since April 22nd, for those of us who have made a career, and I've been in this field for over 30 years, who've made a career out of working with multinational companies to sponsor foreign national workers, this sword of Damocles has been hanging over our head for the last couple of months, and has been the result of intense advocacy and even more intense rumor mills. So let's move on to okay, so you're already on the background side. So what essentially was in the proclamation? So as it says, we learned that there would be impact on non-immigrants, and we learned on Monday of this week that it was going to be signed. It's effective. It was effective as of Wednesday. So it's effective now, and it will be effective through the end of the year, and it may be continued or modified as necessary. The proclamation also extended that April 22nd proclamation banning the entry of certain immigrants to the United States. So that's the core of this proclamation. And now maybe if you can move the slide, Molly, we'll talk about what non-immigrant categories were affected by the proclamation. So essentially for very mainstream non-immigrant visa categories for companies sponsoring foreign nationals. The first and maybe the most widely publicized of those categories so far, at least, is the H-1B category, which is the category for temporary professional workers. And interestingly enough, this category, before 1990 and the creation of the O-1 visa, was the mainstay for a wide range of professional activities, including fashion models coming to the United States to work in their profession and maybe possibly marry someone and fall in love with a real estate mogul. The H-2B category is a temporary short-term category for skilled workers, and it's used in a broad range of industries for peak load or temporary or seasonal services. And in the media, it's been widely publicized that this H-2B category has been utilized by a certain luxury resort in Mar-a-Lago, Florida, to hire dozens and dozens of cooks and servers over the years. So it's interesting to look at the impact of this category on types of foreign workers. The J1 category is the next category. It's for exchange visitors in training and internship positions, and it's well known to those of us who've been working in the FACC for a number of years. And just by way of background, it was a category that was created in the height of the Cold War. It was part of this country's efforts, if you will, to win the hearts and minds of foreign countries and nationals around the world. And in fact, it was a key part of our efforts in the Cold War during a time at which we were engaged in a global conflict with essentially Russian communist ideology. So that's the third category. And then the last one, which actually I think has caused more scratching of heads than almost any other, is the L1 category for non-immigrant temporary workers. And the L1 category allows for executives, managers, and specialist personnel to come to the United States to work temporarily for the company that they had worked for overseas. And within those three categories, while the specialist category, because of its usage over the years, may lead to a more nuanced and more detailed conversation about its impact on US workers, the L1A category for executives and managers has long been considered a category that really did not have an impact on the employment of US workers, and in fact may have a positive impact on the employment of US workers by allowing overseas companies from France or Germany or Belgium or the UK to actually open up operations and send key leadership personnel to get the business off the ground and running. In fact, there is for L1A executives and managers, there is a statutory exemption from labor market testing for executives and managers in the context of the green card process. So it really was hard to understand the applicability of these various categories, of that particular category and these categories in various aspects to the goal of this proclamation, which was improving wages and working conditions and working opportunities for workers. So H-1Bs, H-2Bs, J-1 visas, and L-1 visas all included in the ban. Next slide, please, Molly. So to whom does this apply? Essentially, it's any individual seeking a visa in one of those non-immigrant categories who does not have a visa or other documentation permitting admission to the United States. That's essentially what that slide says. So if you're in the United States and you have a valid visa on the effective date of the proclamation, which was June 24th, you should not be impacted. And we'll talk about this a little bit more when we get to the end of the presentation about some of the open issues that we're still trying to seek clarification upon. That's to whom it does apply. So next, the proclamation also included some exemptions. So not surprising here, the exemption doesn't apply to individuals who are permanent residents or very close family relatives of US citizens. There is an exemption which has appeared before relating to individuals essential to the US food supply chain. And then lastly, to those individuals who are deemed to be in the national interest by the Secretaries of State, Homeland Security. So I think that there's a narrow pool of exemptions that applies. And let's maybe just talk a minute about that national interest exemption. If you can move on, Molly, to the next slide. So I'm not going to go through this in great detail because none of it probably should be particularly surprising to anyone, but those who are critical to the defense or national security of the United States can apply for an exemption. Those involved in either COVID treatment or research are also part of this national interest exemption. It is interesting to note that this is a more narrow exemption than the exemptions granted to the medical community as a whole in the April 22 proclamation. There is also an exemption for those who are deemed necessary for the economic recovery of the United States. And then as a result of extensive lobbying by the immigration community and actually the threat of litigation, there is an exemption for those who might have aged out, i.e. reached the age of 21 and become ineligible for visa eligibility because of the proclamation. So let's move on. So with that quick overview of the basics of the proclamation, what was significant to me, or one of the more significant aspects of the proclamation to me, and very similar to what I said earlier about the April 22nd proclamation, is that there was a section that dealt with additional measures to be considered by the executive branch, in addition to the restrictions on applications for the H-1s, the H-2s, the J's, and the L's. So here are, in very short form, some other measures that are included in the proclamation. The first being that the Secretary of Health and Human Services is to provide guidance on measures to reduce individuals seeking admission from introducing or spreading COVID-19. That is likely to lead to the requirement of any individuals applying for visas to be subject to COVID-19 testing before arrival. That's the only way I think I can read that provision, in terms of current events. So it's more likely now that we will be requiring COVID-19 testing once we're up and running again and issuing visas at embassies and consulates abroad. The second one, which actually was, again, I think this proclamation's sword of Damocles, is issuing regulations or taking additional actions to ensure that those who have already been admitted or are seeking admission as an EB2 advanced degree professional immigrant or an EB3 professional immigrant or an H-1B non-immigrant do not limit the opportunity for U.S. workers. So leaving aside for the moment of how this is going to apply to people who've already been issued permanent residence in those categories, I think what is most concerning is that it's going to possibly add additional labor market testing to the EB2 and EB3 categories. And in fact, there was an article in Forbes, I think it was yesterday or maybe the day before, that suggested that there could be a second labor market test added to the permanent residence process in those categories, particularly as it applies to foreign nationals who've been subject to long backlog-related waits in the green card process. So that is something that we're going to watch carefully, and I think, again, there'll be the additional advocacy as well as probably the additional rumors around that one in the very near future. The third measure referenced in the proclamation relates to regulations or other actions concerning really the presence of H-1B workers in the United States and their impact on U.S. workers. Again, no formal information from the administration on that, but it seems likely that this may involve some regulatory activity prioritizing H-1B workers based upon their compensation. That is to say, the more highly paid the H-1B worker, the more likely it is that they'll be given priorities in terms of the annual allocation of H-1B visas. And lastly, ensuring that individuals will not be able to apply for a visa or admission to the United States until they've completed appropriate biometrics. Now, I'm not sure what that has to do with protecting jobs for US workers and improving the economy, but so be it, it's in the proclamation. So let's move on, Molly. How are we doing on time? Pretty good. We're almost done. So what are some of the questions arising from Monday's proclamation? So the first question that's been asked, what is the immediate effect? And again, the answer is probably pretty limited in the near term. As I said, with respect to the first proclamation, the embassies and consulates, US embassies and consulates around the world really aren't issuing non-immigrant visas right now. They're not issuing H1s, H2s, Js, or Ls. So at least in the near term, it's not likely to have a significant effect. But if later in this year, the embassies and consulates do open up, or I should say when they do open up for non-immigrant visa services, individuals applying for those visas, and particularly those H-1B workers who've just been successful in filing H-1Bs for this year's CAP season, will be precluded from entering the United States at least until the end of the year. So question 2, what is the impact on foreign nationals in the United States? Because of the way the statute is written, its impact on those who are already here in a HJL visa, they should not be impacted. So there have been some questions about that, I know, in the Twitter sphere, but I think that that's pretty clear, again, based upon the statutory limitations imposed on the president in terms of making these emergency proclamations. What about visa renewals? Well, it would seem to me from the very wording of the proclamation that if you had a valid visa on its effective date and you needed to apply for a visa renewal, you should be able to do it. So if you were in the United States and you had a valid visa on the effective date of the proclamation, and you subsequently need to get a new visa, your stay is extended and you need to get a new visa stamp, that should be possible. But I would warn you very carefully, talk to your counsel about this before you make any plans to travel abroad for a visa stamp. There was a tweet by the State Department which seemed to indicate that this may not be as clear as it would seem from the proclamation, and that individuals applying for visa renewals after the effective date of the proclamation may not in fact be eligible. So I think tread carefully on that. I'm sure that's going to be the subject of additional clarification in the near future, but my advice is talk to your counsel, make sure you're making an informed decision before you travel. Another question that came up earlier this week, what about visa exempt individuals? So for example, a Canadian national applying for admission as an H-1B or L-1, the proclamation does not, it's been confirmed by the CBP and other agencies, it does not apply. So Canadians are not involved or affected by the proclamation. What about the effect on US worker employment? Well, when the proclamation was announced, it was suggested that the effect of this proclamation would actually provide over 500,000 more job opportunities for US workers. Subsequent to that announcement, there has been a number of articles challenging the science, the economic science of those estimations, and suggesting that it's not a one-for-one translation. So, removing these opportunities does not necessarily mean US workers will be hired. So it's unclear as to whether that 500,000 job opportunities is really going to translate into 500,000 opportunities for US workers. But even if it does, we're at a time when it seems almost every week we're adding over 1 million US workers to the unemployment rolls. So over 1 million, I think it was something like 1.4 million Americans were initial applicants for unemployment benefits this past week. So given the relative impact of this on our current economic situation, unemployment situation, I raised the question earlier in a blog this week as to whether or not the administration is really working hard or working smart to solve this economic crisis and the unemployment that's been created by it. There are numerous articles highlighting the fact that the employment of foreign nationals, particularly in some of these categories, actually create more jobs than they take in the United States. So what about L1A executives and managers? Again, that one's a real puzzlement to me. And I think that one of the concerns that has been raised in the media is the possibility for retaliation against U.S. managers and executives working abroad, around the world. We'll see how that plays out over time. And there have also been questions about whether or not this is in violation of a U.S. accord that the U.S. signed, the General Agreement on Trade and Services, that provides for free movement of executives. So we'll see how some of these efforts, but certainly this is the United States going off in a direction that is of questionable impact on U.S. worker employment opportunities, and possibly in contravention of prior long-established agreements. So the last point I'll just raise before we turn it over to questions is, what are the prospects for litigation? So if you've been following U.S. immigration policy these last several years, it's pretty apparent to you that pretty much any proclamation that comes out of the current administration has the potential for being subject to litigation and could be subject to an injunction preventing, at least temporarily, its administration. So, and I think that could very well be the case in this particular circumstance. So I guess what we may see is, and my understanding is that, at least for the past several weeks, there have been preparations for litigation in anticipation of the proclamation being issued. So hard to say with any certainty what the prospects of that litigation might be, particularly in the context of the current Supreme Court. But if you look at actually the recent decision on DACA from the Supreme Court, it would seem to suggest that when the administration takes actions that have broad and significant applicability to a certain class of individuals, that they need to provide a very specific explanation of the rationale and the impact on those foreign nationals. So that may not have been done here, and that may be a basis for some litigation. In my mind, there's actually a more interesting constitutional question that has been raised here, which is with respect to separation of powers, which is a fundamental concept of our constitutional government. And while it's been established that the legislative branch can delegate responsibilities to the executive, the question really arises: is there a limit? At what point is the executive action beyond the scope of this delegation doctrine? And is the effective elimination of several visa categories more than really that delegation doctrine had anticipated? So these are questions that could lead to further litigation on this proclamation, as well as the prospect of an injunction, maybe limiting its enforcement until after the election. So at this point, there's a lot more I'd like to say on that issue, but I think why don't we stop right now, Molly, and we can turn this over to the Q&A session.
Yes, sounds great.
I can stay for more than 5 minutes. I know we scheduled this for 30 minutes, but I'm happy to stay on for a little while longer if people are interested.
Okay, yeah, it looks like we already have a couple questions in the chat. So I know there were a couple. I'm going a little bit out of order because it's a more general question. Someone had asked, why aren't e-visas affected, at least not yet?
Good question. I think the e-visa, like what used to be known as the NAFTA, the treaty visa, were, I think, intentionally omitted from this proclamation because they are based upon reciprocal treaties, specific reciprocal treaties that have been entered into by the U.S. government, in this case with France, but with many countries around the world. So I think there was a conscious decision not to abrogate those treaties with this proclamation. And I don't anticipate, at least in the near term, that they will be included. I have not heard a word on that.
Okay, and thank you. And we also have a question about spouses who filed for a green card. Are they still going to be processed? Should we anticipate delays?
Well, again, the first proclamation, which limited the ability of individuals to enter on immigrant visas, really only applies to those who are seeking green cards at U.S. embassies and consulates abroad. So an individual who is here in the United States and who has applied for permanent residence and presumably adjustment of status as the spouse of a U.S. citizen is not affected by either proclamation. and the statutory provision that allows the president to exercise emergency powers in this area refers specifically to entry. And that's a technical legal term. And if you're in the United States, then you have already entered and then would not be subject to these proclamations.
And then similar, I'm sure this would affect processing times potentially. We have a question. USCIS declared a few days ago that they may have to furlough up to 50% of their staff without emergency funding. Do you think that could delay any ongoing processes?
Oh, I saw that as well, and I think that I have a real concern about that, and I think that's and I actually blogged about that earlier this week. I think that is one of the unanticipated, unintended consequences of the situation that we're in right now. Is that the demand and the filing because of the economic conditions is way down. So if there isn't additional funding, then the agency will be constrained in its ability to adjudicate petitions and applications, which will clearly, I think, affect processing times. I don't think there's any way around that. So.
And then we have a couple more specific questions. One of them is, this is from one of our guests who said, I'm in France, married to an American. We filed for a green card, and I am still in France waiting for the visa. Will I be affected?
Well, if you're applying for permanent residence, you're more affected by that April proclamation than you are by the proclamation this week, which really was focused on non-immigrants. So, again, the embassies and consulates are closed, so it's hard to have any type of visa application process at the moment. But if in the course of the next few weeks or months they do open, this proclamation will make it impractical for you to be able to complete processing at an embassy or consulate abroad. So I think there are, there are a number of stories. If you look in the media, there are stories of individuals. I just saw one yesterday evening about an individual who went abroad in February to India to get their H-1B stamp issued and was first delayed by COVID-19 from being able to get their visa stamp. And now looks like they're going to be precluded from entering the United States, getting a visa until at least the beginning of next year. So a 10-month delay. And just, parenthetically, that's raised the question of what's going to happen to that individual and their job. And after having 10 months of virtual employment abroad, will that U.S. employer want to actually bring them here, or will they just keep them overseas with, the obvious impact of, losing the state, federal, and local tax revenue, losing the opportunity of that individual as a consumer of U.S. services and supporting the U.S. economy. So, there are lots of unintended consequences as a result of some of these proclamations, and time will just have to tell how significant they will be.
And then we have a couple other questions. I think they're potentially the same one. They're certainly complementary. So a general question about, are there any travel bans on Americans to Europe today? And then following that, is it possible that France could reciprocate by withholding similar visas for Americans wanting to enter France? I don't know if you want to address those separately or together.
Well, I think yes. I mean, there are still limitations on the ability of Americans to travel abroad. I think, I guess there's possibility if you're willing to quarantine. I think there are rules that allow you to quarantine in place. So it's not easy to travel for business. And what was the second question? The second part?
So the second question was, are there any travel bans on Americans going to Europe today? And then specifically, do you think that France would reciprocate by?
So the reciprocity issue is interesting. Again, I referenced earlier GATS, the General Agreement on Trade and Services, and most developed countries have signed on to that, and that has provisions that apply to the facilitation of entry of executives and managers, in short. So this technically could be deemed a violation of GATS and could be the subject of some recourse within that agreement. But beyond that, I think we'll have to see the extent to which this endures, right? So I haven't talked about the political facet of all of this, right? So we are right now entering like the key period of a presidential campaign with an incumbent who has, based his candidacy for the last 4 years on improving conditions for U.S. workers. So it's going to be, it'll be interesting to see in a time right now where we have such high unemployment, how that election all plays out. And one could posit a situation if there is a new president come January, that these restrictions, which may have been enjoined in court anyway, may ever take effect. So that could be one outcome. So we'll have to see what the real effect of it is. But certainly, reciprocity is potentially an issue here. So much of immigration policy, right? So in terms of visa validity, right? We saw that with e-visa not that long ago with France, where there are changes that are primarily driven by reciprocal treatment of U.S. nationals going to France. So I think it is something to watch carefully.
Mm-hmm. Mm-hmm. And then we have a specific, looks like a very specific question on an Austrian student who received a scholarship to attend college in Tennessee this year. I don't know if our guest wants to unmute him or herself and ask the question, because it seems, I don't want to misstate the question. It seems very specific on if this student will be allowed to enter the U.S. to attend college in Tennessee this fall or stay in a self-imposed quarantine.
The short answer is right now the embassies and consulates are not processing visas. So it is something that we will need to watch from that perspective. But the proclamation has no impact upon students. It really is on work visa categories. Even within the J1 category, it didn't really address students. It addressed those categories that provide for some hands-on training or work activities in the United States. So it's going to be less a function of the presidential proclamations, at least to this point, in terms of students coming to the United States, than it is access to embassies and consulates to process visa applications. And I would add at this point, I think that there's a very strong and effective advocacy effort within the Capitol for the major colleges and universities. So I would expect that that is an issue that is receiving a lot of attention in DC right now, because we're really just entering into that period, or may have already entered into that period, where F1 students are applying for visas to enter the United States. So all of this is, again, sort of wound up within COVID-19 and what schools are going to be doing in terms of actual physical classes versus online classes. But I think that in terms of that question, access to the embassies and consulates will be key to determining whether or not that person is going to be able to get a visa and enter the United States.
Mm-hmm. Thank you. And so that's all of our chat questions that I currently see. If I missed any, doesn't look like I did. So I'll invite anyone who may have a question they want to ask out loud now to go ahead and ask. Looks like we have, correct me if I'm wrong, Michael, about 5 or so minutes for any.
Yeah, there's no harm in ending early, but I think that if there are other questions, we're happy to hang on there. And I think, again, as someone who's followed the history of immigration and the fact that these categories have such a long history of helping the U.S. economy. That's why they were created, right? They were created to actually create opportunities for foreign nationals to come here. So hopefully they would better the United States and our economy. So I think, from my perspective, really, as I said earlier, we would all agree as Americans, I think, or even anyone, we would all agree that it's important to try to find ways to help the economy recover and address the real tragedies that so many Americans are facing right now in terms of their economic outlook. But again, I feel the question is really, are we working harder or are we working smarter in denying access to individuals who have historically shown, and this has been proved by economists over the years, that they do more to help the economy than they could ever possibly do to harm it. So that's really, I think, a really important question that we should be asking our leaders right now. is this something that's really going to be helping us or hurting us over the long term?
Thank you. That's absolutely, there's plenty to think about. And I think, I imagine there are a few others who have questions who I know not everyone's comfortable with chat or asking out loud. And so thanks everyone who's attended today. I'll wrap up by saying thank you, Michael. And also I'll be sending out a follow-up email so you can connect with Michael and myself or our executive director, Andrea, who's been on the call as well. We'll have all of our contact info and then our upcoming events as well. And again, if you have any more specific questions for Michael, he'll be able to answer those. So
And please mark your calendars for July 22nd, La Nuit des Étoiles virtual gala.
Exactly.
It doesn't cost a penny. All you need to do is click to attend.
It's free to register, and I'll have that link in there too, and you can always reach out and ask. And then as a final note, we'll have this available in our webinar archives in the next 24 hours. So anyone can watch this back. Thank you, everyone, and happy Friday.
Thank you. Take care.